In a significant verdict, the Supreme Court on Thursday unanimously struck down the electoral bond scheme as unconstitutional. A 5-judge constitution bench, headed by Chief Justice of India D.Y. Chandrachud, delivered the judgment on a batch of pleas challenging the legal validity of the central government scheme which allowed for anonymous funding to political parties. The bench held that certain amendments made to the law introducing the electoral bond scheme were violative of Article 19(1)(a) of the Indian Constitution that guarantees Indian citizens the right to freedom and expression. Consequently, the bench declared Section 29(c)(1) of the Representation of People Act 1951 as amended by Section 137 of the Finance Act 2017, Section 182(3) of the Companies Act as amended by Section 154 of the Finance Act 2017 as unconstitutional.
According to Clause 7(4) of the Electoral Bond Scheme and the amendments, the information about contributions made through the Electoral Bond Scheme is exempted from the disclosure requirements. This information is never disclosed to the voter. The purpose of securing information about political funding cannot be fulfilled by absolute non-disclosure. B. We have proceeded to apply the subsequent prongs of the double proportionality standard, assuming that the suitability prong is satisfied. Section 29(c) of the Representation of People Act, which states that information of contributions made below Rs 20,000 in a financial year need not be disclosed, is a lesser restrictive means to achieve both the right to information and the right to informational privacy. The underlying rationale of Section 29(c)(1) is that contributions below the threshold do not have the ability to influence decisions, and the right to information of financial contributions does not extend to contributions which do not have the ability to influence decisions. Similarly, the right to privacy of political affiliation does not extend to contributions which may be made to influence policies. It only extends to contributions made as a genuine form of political support. It is quite possible that contributions beyond the threshold of Rs 20,000 could also be a form of political support and not necessarily a quid pro quo arrangement, and contributions below the threshold could influence electoral outcomes. However, the restriction on the right to information and informational privacy of such contributions is minimal when compared to the provision of blanket non-disclosure. Thus, this lesser restrictive alternative realizes the right to information of an informed voter and informational privacy to political affiliation in a real and substantial manner. The Union of India has been unable to establish that the measure employed in Clause 7(4) of the Electoral Bond Scheme is the least restrictive means to balance the rights of informational privacy to political contributions and the right to information of political contributions. Thus, the amendment to Section 13(a)(b) of the Income Tax Act, introduced by the Finance Act 2017, and the amendment to Section 29(c)(1) of the Representation of People's Act are declared unconstitutional. The question is whether this court should only strike down the non-disclosure provision in the Electoral Bond Scheme, that is Clause 7(4). The anonymity of the contributor is intrinsic to the Electoral Bond Scheme. The Electoral Bond Scheme is not distinguishable from other modes of contributions through banking channels such as checks, transfer through the electronic clearing system, or direct debit if the anonymity component of the scheme is struck down. Thus, the Electoral Bond Scheme 2018 will have to be struck down as unconstitutional.
Furthermore, the Supreme Court directed the State Bank of India to immediately stop the issuance of electoral bonds. The bench also ordered the SBI to submit details of all electoral bonds purchased since April 12, 2019, when the Apex Court passed an interim order on the matter till date to the Election Commission of India. Additionally, the Election Commission has been directed to publish the details of electoral bonds on its website by March 31, 2024, ensuring transparency in the electoral process. The court also ruled that any electoral bonds that have not been encashed by political parties should be returned to the bank, which will then be refunded to the purchaser. Manish Parab and Omkar Deshprabhu for GOA365.